I trust it's suspect it's still on strike yet.
No, but we remain tutoring. It'll take us forward.
Look over the edge of the clip and see where I get to. So I left this with that question. The question goes down to a reasonable registrar reading the development is all the answers that I should give to them. But to approach that question, you have to look at the 2011 measures, because as we've already touched upon this morning when you were listening to Learning Fred, the registrar has to satisfy, when it's a she herself, that the prospective applicant has standard before issuing the notice. And that naturally requires the registrar to investigate what took place in the proceedings below. The registrar could not have performed that statutory function without doing so. Accordingly, in my submission, we have to impute that a reasonable registrar's knowledge of the let me just read that again. We have to impute to a reasonable registrar knowledge of the proceedings below. Now, at the hearing before the commissioners, Lee Day acted for both Reverend Clark and the PCC.
Right.
And this was apparent from an email exchange between Lee Day and the PCC before the hearing. And can I take you to, in the bundle, page 723? That is part of the context which a reasonable registrar reading the notice would have been aware. I'll just allow your lordship to. Yeah, 723. It's the email exchange following that.
How would the registrar see this exchange?
Coming to that.
Yes, okay.
Sorry, where do you want us to read?
Sorry.
The 26th of August statement where Mr. Bond confirms that Lee Day would be representing Yvonne Clark. Says it would be representing Lee Day and Yvonne Clark from All Saints PCC.
And she produced a statement, didn't she?
Yeah. What is clear is that you'll see Rex Andrews. He's for the church commissioners.
He understood it as representing the Reverend and PCC. At the top of the page.
Yeah, exactly.
At that hearing, anyway.
Yeah, yes. And this correspondence would have been part of the registrar's investigation, because the registrar would have had the papers and the proceedings below.
But but she didn't.
So why would she?
Because
my lord, 2 points on the relation to that. Firstly, just go with me. That's a lot. Good. Under paragraph 3 of Schedule 2, that we find at 1612.
Insert people.
I didn't know that. The registrar's function is to satisfy itself that the proposed paper is duly made representation to the commissioner. That requires, we say, the registrar to have detailed knowledge of what took place in the proceedings below. It wouldn't be enough just to read the question statement of reasons. That in turn means that a reasonable registrar would have had to have made inquiries with the commission.
Well, wouldn't the ordinary thing be just for the person that
is giving notice to confirm to the registrar and I satisfy the conditions.
Well, yes, that's one way, but I invite you to ask this, to examine this. The critics could you receive a communication from the solicitor's firm and litigation, and that communication doesn't specify for whom the solicitor is acting. But you know, up until that point, the solicitor has been acting for, has been being instructed by two parties jointly to the litigation in question. What would you reasonably assume? I would suggest you would reasonably assume that that solicitor continues to act for both parties. That they
It might be knew that, but the registrar didn't. Well, you've got to pretend that you did, because perhaps that's something you ought to have found out.
Well, here, that the commissioners knew at the hearing that Lee Davis representing both the PCT and the Reverend Dodd, and unless indicated otherwise, we say that the reasonable registrar satisfying herself in relation to her statutory requirement must have made those inquiries of the commissioners in the hearing below, and therefore we can assume that the reasonable registrar would have known that the appellant, the notice of appeal, was submitted on behalf of both.
But I would have thought the obvious thing for the registrar to do if she was carrying out her duty was to phone Lead A and say, for whom are you acting? And that there's no question of you putting forward any sort of any note from the file that such a telephone call would be made, or was made. Why phone the church commissioners when you obviously phone the agents acting for the unnamed principals?
Well, or if it was in lockdown, then if it was, you send back an email saying, you know, thanks for your email, but I can't take it forward unless you tell me who you're acting for.
She had not heard that. We said,
And give information to show that you made written representation to the in relation to the scheme. I think that she had to ask for that.
well, my lord, there's a communication from the solicitor's firm that the registrar received. No further inquiry was made. We assumed, and I think it's reasonable to assume, if the registrar was conducting her statutory function under Schedule 2,
I don't understand the principle who say that because the registrar should have done something, we were to proceed on the basis that she did. But what is the legal principle that you're relying on? I'm not aware of one.
well, to look, my lord, I see difficulty, and what I say about this, given the context of the measure, that naturally requires the registrar to have satisfied herself, and that means that some investigation of the proceedings below ought to have taken place. Otherwise, how could the registrar perform her statutory function without doing so? And therefore,
Well, one answer is that she didn't perform her statutory function.
Yes, but ultimately your case has to be that we must infer that she did.
yeah, well, yes, and that's what I say that you must mention that, because we have to impute that a reasonable registrar's knowledge of the proceedings of below before Schedule 3, Schedule 2, Paragraph 3, can be performed.
I mean, one analysis of the facts is that you gave a notice on the 5th of November,
And it wasn't.
and there was never any notice given by the registrar, although there should have been, but there wasn't.
That being so, if we look at that alternative, the registrar can still now issue a late notice on the paragraph 3, Schedule 2. that means that the appeal is still in tie, and the issue in relation to an extension of time goes away. But
That won't cure your problem if your notice wasn't valid when it's given on the 5th of November.
I think we take things a stage at a time, work through the different issues.
Can I deal with the use of the singular term appellant in the email, the 28th of October email? I say that, again, a reasonably registrar reading that if there had been any exchange in the parties from whom the firm had been instructed, if there had been any change, the firm would say so. In the absence of any such statement, a reasonable registrar would still assume that the solicitors were still acting on behalf of the same parties, but I accept that comes down to whether or not that knowledge was provided to the registrar. So, can I summarise this point in 7 short submissions? Firstly, I say a reasonable registrar would, because of the statutory obligation under the 2011 measure, which mandates the registrar to ascertain the standing of the prospective applicants before issuing a notice, if a notice was issued, necessitates an investigation into the proceedings below. Contextual awareness is important because a reasonable registrar would necessarily possess the detailed knowledge of those proceedings, including Lee Day's dual representation of both the PCC and the Reverend Clark. Thirdly, it's a reasonable assumption in the absence of explicit clarification that the solicitors who were in the litigation continue to act on behalf of the parties they previously represented. Fourthly, in terms of the interpretation of communication, the use of the word appellant in an email from Lee Day should be viewed either as a mistake or just colloquial language. Some people just say appellant when strictly they should be saying appellants, and is not indicative of any change of representation. Fifthly, the logical inference, given the absence of any indication of a change of representation, a reasonable registrar would interpret the notice as being given on behalf of both Reverend Clark and the PCC jointly. And this is sixthly, a sensible interpretation aligns with the logical expectation in the legal proceedings, which reflects a contextual understanding of the ongoing representation by Lee Day.
I can see if you were putting yourselves in the shoes of a third party trying to work out what the registrar had done, that there might be something in it, but we're to put ourselves in the recipient of the notice, take the position of the recipient of the notice, and the question is not what the recipient of the notice would do, but how they would understand the notice when they got it, with the knowledge that they had at that stage.
Well, my lord, I would submit it's not just limited to that, because the registrar would then have to ascertain whether or not the individual or the person sending the notice had standing, and that's when the investigations would happen.
Yes, you're distinguishing the cases on notice where the notice itself was everything, with the what you say is your circumstance where the recipient of the notice then has to carry out a statutory task in relation to the notice.
Exactly. There's an additional step, and there's a statutory obligation on the registrars in this case, which is different from the other cases, to satisfy herself. And that must have, just to finish the point, this is the last thing I say, and then I'm going to move on because I don't want to continue making the point if you're not persuaded by it. But the final point that I will make on this is that if the notice that was served, and this, if we go back to the earlier email, the one that was served, the first one, one assumes that it's reasonable to impute that that's what the registrar did when the registrar served the notice. Right, let me move on.
When she gave her notification.
Exactly.
Yes, thank you.
Let me move on to the second jurisdictional issue, and this is where...
Can I just ask you, I mentioned before lunch, in paragraph 15 of your case, you claim that it identified the first but not the second defendant. I'm not quite sure where the distinction between comes from, or if it's one you still maintain and say about your case. You know what I'm talking about?
I do, yeah.
It's on case 988, it worked with Trump,
I think we're just barely close.
we put him told the second defendant.
Yes, yeah, what I had in my mind there was because the clerk had not been identified. It's got that reference to the class.
Well, I understand that half of it. It's the other half I was wondering about, which is how all saints have been identified. What difference there was, and I could say that one was, even though the Reverend Clark wasn't.
Just turn to the form.
Chair, and so it's a high making special.
My lord, can I come back to that? My lord, can we? Can I come back to that? I might lose you. Yeah. Okay. Can I just deal then, if I may, and I'm moving on to the second jurisdictional point as I see it, and that is, if notice was served, and I appreciate there's an issue as to whether or not, because we've asked for the registrar to serve a notice, there's an issue as to whether or not time has actually run. So this only applies if the first email, which it is said to have triggered notice, and not the second email where the appellants were asking for the registrar to issue a notice.
Great.
If that makes sense. So if we are talking about the first notice being validly served, and the issue is whether or not the board has power to extend time because of the fact that the appellants were appealed late. And what I say is, in the written cases, my learned friends argue that the time limit under the measure must be interpreted as absolute. Because section 12(3)(b) prescribes the consequences of not filing a notice of appeal within the time limit. Now, I've already addressed the argument, but let me deal with it in this way. My submission is applying the approach of 3x, and the comments I've already made in relation to Sir James Mumby. The General Synod and Parliament cannot be taken to have intended the time limit in this case to be absolute. The consequence would be that where a party or their lawyer made a mistake, it would be shut out of court forever as a matter of a consequential, on a matter as consequential as the abolition of a parish and the consequent dispossession of an incumbent of 26 years. And I say that this case is radically different from the case of Shahid, where the restriction was one put in place to protect an individual from state abuses of power. So it was quite right in the case of Shahid to adopt a really strict ruling because you're dealing with the individual rights of prisoners. But there are 4 reasons why I'd ask your lordships not to follow that approach. Number 1, parliamentary intent. My learned friends argue for an absolute interpretation of time limits based on prescribed consequences for non-compliance. However, it's essential to consider parliamentary intent and applying the approach of re-ex. In my submission, it's implausible to presume that the General Synod and Parliament intended that a mere oversight would result in the permanent exclusion from a legal recourse. Number 2, consequential ramifications. The gravity of the matter at hand potentially leading to the dissolution of a parish and the displacement of its incumbent of 26 years underscores the need for a pragmatic interpretation. Unlike cases like Shahid, where strict interpretations serve as a safeguard to individuals against state abuses, here the strict application of the time limit could lead to disproportionate and irreversible consequences for individuals and communities, the parishioners and the minister of this parish. Thirdly, protection of rights. Extending the time limit aligns with the domestic principles of statutory construction, aimed at upholding fairness and safeguarding individuals' access to justice. It ensures that individuals are not unjustly deprived of their rights to be heard due to inadvertent errors or procedural missteps. And fourthly, the fourth reason I put before your lordships is Parliament and the General Synod must be taken to have intended to establish a fair procedure that could be easily navigated, if necessary, by lay parishioners, and which does not erect undue barriers to access the court. You see, if these potential applicants were deprived of access to the court by procedural missteps, regardless of whether any other party suffered any prejudice, that goal would not be achieved. And I submit that to your lordships that you could conclude, using those principles, that the time limit in this case is extendable simply on ordinary domestic principles of statutory construction, even before we get to any arguments on convention rights. But if I'm wrong on that, in the alternative, I rely on Article 6, and I say that Article 6 is engaged in this case for the following reasons. Now, my learned friend makes reference to Atienne against Finland, and you'll find that at page 3322 in the bundle. That's 3322. That for the proposition that it is not, Article 6 is not engaged. However, in my submission, careful attention is required to the reasoning in Atienne. In that case, the Strasbourg court held, and I would invite your lordships to, I'm not going to read it to you because your lordships can read it for yourselves, but can I take your lordships to paragraphs 38 to 43 of Atienne, and you'll find that at pages 3332, that's 3,332 to 3,333. And can I ask you to read make the quote, which begins, this right to a court down to summing up, no basis therefore has emerged in the domestic law.
It's just the head note was raised.
So the top paragraph on 3332, paragraph 38 says this right to a court, and then there's a quote. That's it, is it?
Yes, correct.
house. Can't tell you.
So,
It was short meeting. What's that? All right. Ah.
just bear with me a second.
That's never. Sorry. That's. This thing. Because that I didn't know which one. That's where is the place was going. The stand. Yes. It's go.
So is this right? This case was concerned with someone who was effectively being told to move jobs,
Exactly.
but not losing their job.
Two things. My lord is absolutely right. And can I develop the issue, because this was a question of employment law, which in Finland is different than under the Church of England. Let me develop it. In my submission, the court's conclusion in Etienne that the applicant did not have a right within the meaning of Article 6 was influenced by a number of factors. First, the decision was purely a discretionary one, which required only a justified reason. Secondly, the legislature had not provided for an appeal on the merits. Thirdly, the relevant legislation left it to the church as employer to determine the place and period of the pastoral activity. In short, my lords, on the facts of Etienne, the applicant simply did not have a civil right to remain in his current parish because no right existed under domestic law.
I'm just going back to what I was asking about. I mean, I see from paragraph 42 that the court is sort of cross-referencing other authority which did relate to priests losing their job as a cleric. So that doesn't seem to be a point of available as a point of distinction. Is that right?
The court makes reference to other cases where priests lost their jobs, but in those other cases, including in Etienne, there wasn't a right that had been given under domestic law, and the point that I would make is, here, in this case, you have the position of a freehold incumbent of the Church of England. That's completely different. The Reverend Clark's position and what she held as a freehold office holder has all the characteristics of a civil right for the purposes of Article 6. Reverend Clark holds a freehold office, which carries with it legal rights and duties under domestic law, under our domestic law. That office carries a degree of security, of tenure. She isn't an employee who can simply be transferred by her employer to one post and to another, unlike in Etienne. Although the scheme can be made abolishing a parish, as is proposed in this case, it involves an elaborate procedure and the payment of compensation to the incumbent. And unlike in Etienne, where the legislature had provided for an appeal on the merits against the pastoral scheme, not just an extraordinary appeal, in my submission, a freehold office in the Church of England, has all the characteristics of a civil right. Of course, it's true that no parish is assured of its future existence, but most civil rights and obligations under domestic law are not absolutely assured of their future existence. For example, in this country, if you have a property right, which is a civil right par excellence, that can be subject to compulsory purchase. So the fact that a freehold office is not absolutely secure against abolition does not deprive it of its character as a civil right. Now, I can see that at paragraph 42 of Atienne, that's 3333, that's 3,333, that could be read as establishing a broader principle, but there's a case of Duda and Dudova, and you'll find that in the supplementary bundle at 62 to 70, so that's supplementary bundle at 62 to 70, and there's I think there's a translation there, is likewise a case where there was no breach of Article 6, because the claim right was not recognised under Czech domestic law. It was in Duda, which concerned a non-state church. The Czech courts had held that there was no jurisdiction under domestic law to rule on the employment dispute in question. So Duda does not stand for the proposition that disputes about ecclesiastical ministries are always excluded from Article 6. The reason such disputes were not covered in Duda and Atienne is because they were excluded from the jurisdiction of the courts under, well, certainly in Duda under Czech domestic law, not because Article 6 necessarily excludes such disputes. My lords, if there were an exclusionary rule of this kind, the courts in Atienne would not have needed to have highlighted the discretionary nature of the function or the lack of an appeal on the merits, as those questions would have been irrelevant. The court could simply have pointed out this is a dispute of an ecclesiastical nature and left it at that. But rather, in my submission, there is no such exclusionary rule. Rather, the question is simply whether the civil right in question is recognised under domestic law, and that is a question that depends on domestic law. So if Article 6 is engaged, then it cannot be doubted in line with Pominchowski and Adesina, and you've been given the references, but let me give you those references again. Pominchowski is 2291, that's 2291, and Adesina is 1713. There must be an exceptional power to extend time, there must be an exceptional power to extend time to the extent that Article 6 requires, despite the wording of the legislation. Now,
Is the fact that there's possibility of an appeal here relevant to whether Article 6 applies?
well, my lord, that may well be one of the factors that is taken into account. What my learned friends argue is they say that if that power exists, we have not established that Article 6 requires it to be exercised in the present case. They rely on Clavian against Switzerland, that's at tab 104. That's page 3496, that's 3,496. And again, close attention is required to the facts of that case and the reasoning, because, and this is important, in Clavian, that was a case where the lower courts had misstated the time limit for the appeal in its judgment, and we touched upon that earlier today. And the appellant therefore appealed out of time. The decision not to admit the appeal was not held to be in breach of Article 6. However, I'm going to highlight two distinguishing features. Firstly, in Clavian, the correct time limit was plain from the legislation. The lawyer could have ascertained the correct position from reading the legislation, and you see that at paragraph 7, which is at page 3505. The error by the lower court was simply that it stated the wrong time limit in its judgment. In this case, I say by contrast, the true position was not so clear. It's common ground that the 28th of October email, that's 28th of October 21 email, is not actually intended to be a notice of intention to apply for leave to appeal, and that the registrar's issuance of that notice in response was an error, or may have been an error.
Would you accept it wasn't objectively intended to be a notice of appeal, in which case it wasn't one, and we can forget about this whole line of argument?
Well, my lords, I'm only going to touch upon it. I'm not going to labour the point. In the alternative, as I say, Lead Day were open about the fact that they were uncertain, and that's clear from the correspondence, and sought specific guidance from the registrar as to the correct procedure. You'll see that at page 749 to 750, and that's the email of the 22nd of November 21.
I mean, isn't that clear from the 28th October email that they weren't giving notice of intention? They were asking for guidance.
Yeah.
Well, in that case, I'm going back to my Lord's question. I mean, isn't the answer that it could not serve as notice of intention to seek permission to appeal, because on a legal reading of it, it didn't constitute that?
Yes.
Sorry, are you accepting that?
Well, my lord, I just bear with me.
Yeah, of course. Yeah.
My lord, I think that must be right, because that's what the letter makes clear. If that be right, then I can take this very shortly then. The arguments in relation to, so the position must be that if you accept that it's a valid notice, the second email, then the arguments about the first email are neither here nor there.
I think that's what was being put to you.
Do you have any alternative argument on the 5th of November email if you're wrong on how the reasonable reader would interpret it? Is that the end of it as far as your case goes, or do you have any alternative case on that communication?
My lord, yes. Just
Yes. Because you can have the phone. Walk out. But even for the fun. Was it's permit them out. And it's like something that you know as well. Because you got how to go through the company. But so you are visible. In that you breaking yes. Oh, but I would something yes. All this good. Look at me, maybe but it's just hanging out with us. We try to bring up with that. It's the teacher. And I'm staring at the shoe. I get it. The chin. But you. Yeah. You know, that's a lot of the box. That's rich too. You talk. But that's the. I like to walk this and mention it. They have the speed. That's it. Yeah. 2 days. That shouldn't go. After what happened? Just. Yeah. Just like it. I was missing a little trick. No, so you. Took what?
And will you just bear with me just one minute? I'm just trying to find the document. I'm struggling.
So it's really that I will do this today. How do you get the first time? Still. Say. Stop. Okay. Send. This number is it. Okay. Straight. Let's see. Do that. Stand up. What? It's great. This is a good shit. Wow, not good, but the person. What? So now. In. Okay, wait. Both were as their names. There. If you look, they, since it will be. Feel this. And there's a here. The answer of it. Lost the door. Out of scout. I know. Funny about you. Very soon. We can't keep that. So, did you see things that I have to? Go. Things. On the rest of all. Something else they didn't use that. There it is. There's a. Sure. It's there. So, this is just a big song. They were stuff. In there. It's there. Oh, it's in.
And Lord, apologies. I will check this, but there is one thing that I'm just checking, and I don't know the answer to off the top of my head. But the grounds of appeal, which was sent with Form 1, which you'll find at 8 to 9, which clearly identifies in the heading both the PCC and the Reverend Clark as appellants, and also as in the first paragraph. I'm just checking to see whether or not that document was sent, or a version of that document was sent earlier with the email that was sent, and perhaps I can do that overnight, but that would be the only alternative argument.
Well, you'd be making up a new case there, but I was more interested in the steps of the argument, which are, I think, that if no notice of intention to apply for leave to appeal is given by the date, then that's the end of it. Yeah. I mean, then the second step in the argument is that in order to be a valid notice given by the date, it has to identify on whose behalf it's given. And the third step is that it couldn't identify the appellants. Now, you addressed the third step, but I would just like to know whether you accept the first two steps in the respondent's reasoning, or whether you challenge either of those steps in the argument.
No, I accept those first two steps.
Right, thank you.
I'm not sure, my lord, if I need to address you. Please tell me if you require me to address you in relation to the point that was being made by my learned friend about whether, if we get there, the grounds of appeal didn't properly identify Reverend Clark as one of the appellants. Can I just address you on that very, very quickly? And our argument on that is very straightforward. The church commissioners and the PCC would have been perfectly aware that the appeal and which was attached to the Form 1 made it clear who the parties were. And using the same principles of Newbold, if you receive a document drafted by counsel and the heading says, I'm this document is on behalf of both the PCC and the minister, and the first paragraph also goes into this appeal is on behalf of. Nobody can be in any doubt, no reasonable recipient can be in any doubt that the appellants are both parties. And just test it in this way.
Yes.
Whilst there may have been an argument if an individual was missing, council's not usually in the habit of making up clients and including clients on a document that's been drafted, which is said to be an appeal. That's a simple way of testing that. And so we say that it would really offend.
This was the issue 4 point that you've turned to. Well,
Exactly.
I think you're pushing it a pretty open door in that regard.
I think those are my submissions.
Well, there's issue 1. It may not ultimately matter, but I suppose it's a point that's taken against you that the parish council wasn't in any way somebody who had standing to appeal because they hadn't made written representation.
That's a separate point.
Yeah.
That's a separate point. Can I just deal with that very quickly? My submission is that Julie Maid should be given a liberal construction in the context of the 2011 measure, bearing in mind what I've already said about the proper construction of procedural requirements. And I'd invite you, Richard, just to step back and consider the context. An appeal to the board is the only means of challenging a scheme. And once the scheme has been made, it cannot be questioned in any legal proceedings, and that's section 14(1) of the measure. That's page 1490. Now, that is a very significant constraint on access to the courts. Now, if you think about this, in the real world, most of the time, objectors would be ordinary parishioners who are without the benefit of legal representation, without detailed knowledge of ecclesiastical law. In enacting the 2011 measure, we say the General Synod and Parliament would have been well aware of that. If a narrow construction of duly made is adopted, then there is a significant risk that many objectors will be shut out entirely from challenging the scheme because of their unintended procedural errors.
I don't really understand that because all the objector has to do is make some representation in relation to the scheme, and it's certainly not asking them too much to ask them to have done that before they appeal against the scheme.
Well, we know that in this case there was this measure was not easy to understand. Even the registrar got it wrong. And as I said to you, my lords, it wasn't until 2023, in April 2023, that the objections on jurisdiction were taken. One reads into that. That's probably when the case went to specialist counsel. Given this, I say in my submission that the General Synod and Parliament could have chosen a more precise and unambiguous expression had they intended the right of appeal to those who made representations to be shut out in this way.
But it's very broad, because anybody, as we've been told, can make representations. So it's an incredibly broad.
I accept that.
Opportunity for access anyway. Mr. James Clark could have appealed in his own right if he wanted to.
I make 3 submissions.
Well, you are right that normally when applications for permission to appeal come before the board, they are normally by people who do not have legal representation. So you're correct thus far to say that that is a norm in this procedure.
Let me make 3 short submissions. Here, the PCC, through solicitors, did make representations to the DMPC. The procedure before DMPC is an integral part of making a scheme. We know that the DMPC is responsible for formulating the proposals, which subsequently become the scheme. In my submission, it wasn't the intention of the General Synod and Parliament that an objector who made written representations to the DMPC but did not make timely written representations to the commissioners should lack standing to appeal. That's my first point. Secondly, should I be wrong on that? Is that the representations made by James Clark, and you've already seen those, that's like pages 427 to 433. We say those can be read as representations on behalf of the PCC. In the circumstances of this case, there's several reasons to construe it in Mr. Clark's representations in that way. First, he sent them from his official email address as PCC secretary and not from a personal email address. Secondly, he had already identified himself to the commissioners as the PCC secretary in an earlier email in which he forwarded a representation to them made by a third party. You'll find that at page 387. The commissioners would therefore have known that he was acting as a PCC secretary. And thirdly, third and final reason that I put forward is there is no reason to think that his views did not represent those of the PCC. In fact, other members of the PCC also made representations against the scheme, including Mohammed Barry, who was a church warden. You'll find his representations at page 319. Robert Dubé, on the 29th of August, you'll find his representations at 403. And Winsome Thomas, and you'll find her representations at page 403. Now,
Those are all representations to the commission.
yeah,
And they were all made by those individuals personally.
correct. What I'm saying is, these submissions made by Mr. Clark are in line with other individual members of the PCC. So his views are not different from the views of the PCC. Now, I note an important point in the PCC's out-of-time representations, and those are, you find the PCC's out-of-time representations at 547, and those state, quote, the PCC of All Saints, Spring Park, are saddened to read the Bishop's response to our points raised. That clearly indicates that the PCC as a collective body regarded the previous representations made by individual members as representing the PCC's collective view. And that reinforces the point I say, in substance and in reality, that Mr. Clark's in-time representations, where he sent it from the PCC's secretary, official email, as secretary, were representations on behalf of the PCC.
I mean, this document, page 551, is signed by Mr. Clark as PCC secretary on behalf of the PCC. Might it not be said that that tends to emphasise, if anything, that his other representations were made in a personal capacity?
I can see that being said, but I say that you need to look at everything as a whole.
Is it right you're no longer relying on this letter as a duly made written representation?
So which letters that's
This letter, 25th of November. Because in the statement of issues at 98.4, it is one of the issues.
Well, it is one of the issues, and what I say on that is, so I don't resolve from that. That is my final submission, that the PCC's out of time written representation, that's the 547 to 551, were duly made representations within the scheme. And again, it's my submission that the General Synod and Parliament did not intend to limit the right of appeal to those who had made representations, bearing in mind that most objectors can be expected to be ordinary parishioners with no legal knowledge or experience of ecclesiastical law, and at a time when that letter was when that letter was sent, when the PCC were without legal advisors. So, my lords, those are my submissions in relation to jurisdiction. Can I assist you further?
Thank you very much. A reply in relation to jurisdiction.
Yes, my lord. I'll be short if I can. In relation to issue 2, save further exhortation to read the statutory regime in an extremely broad and I say unprincipled way, we turn essentially to the facts. You have my submissions on the correct legal approach to the measure, and I'm not going to rehash those. And I would, of course, entirely endorse the questions put or comments made by my Lord Legate in terms of the ease of satisfaction of the requirement that one simply makes written representations to the commissioners in response to the notice that has been given and published far and wide. I'd say this in terms of the facts, that this isn't a question of needing to understand the measure before one knows whether one wants to make written representations in relation to the draft scheme. So my learned friend on occasion said, well, the measure's terribly complicated, and how would anyone know whether they needed to make written representations or not? But that puts the question the wrong way round. It's a standing test. And it's very sensible to have standing decided by reference to those who felt sufficiently motivated to put in written representations, regardless of whether those persons knew or did not know that that would generate an accurate right to them. And we see that many unrepresented by lawyers people did make such representations. We see 40 people made written representations duly, including, of course, James Clark on his own account. Now, one of the things that's relied upon now is the email from James Clark at 387. So this was...
One of the oddities in this case is, perhaps unusually, the party appellant were legally represented. Yes, because the norm, in my experience, is that they're not.
Absolutely. Absolutely, I think I can well see that that would be an oddity. And of course, what one sees, just thinking about the measure, how much it's designed in a way that it is workable by those who don't have legal representation, because it is ripped through with obligations on us to notify. We've been to 3 or 4 different notifications, haven't we, today in the bundles, and we have the big emboldened date, we have the obligation to send it to everyone, we put it on the door of the church, we read it out in the services. And so we see how easy it's meant to be for those unrepresented people to make representations. So page 387, halfway down the page, Dear Rex Andrews, so the representative of the church, seen the email reply to Simon and so on, and then it's signed James Clark, All Saints Church, PCC Secretary. So again, I would say that if anything, that actually doesn't help my learned friend, and it helps me because it shows that when James Clark wanted to act as the secretary to the PCC, he wrote it under his name. And when he wanted to wear his hat as the Reverend Yvonne Clark's son, he wrote that under his name, and that's a pretty straightforward way of going about things. I also say that it makes no difference at all that other members of the PCC also made submissions on their own account. The PCC, of course, is a statutory corporation with its own legal personality, as established by measure itself, and we have, of course, Aston Campbell on that if we didn't need other authority. So it simply isn't the case that a number of the natural persons who otherwise sit on the PCC can correspond on their own account, and that can be taken as meaning that the PCC, the legal person, fell within the statutory test. So there we are. Those are my reply points on issue 1. I say that the PCC didn't duly make written representations. Issue 2, very helpfully, we have the acceptance by my learned friend that he agrees that a notice of intention to seek leave needs to be made. If it's not made, the consequence is total invalidity. And he agrees that it is an inexcusable or unavoidable aspect of a notice that it at least convey the identity of the person on whose behalf the notice is being made. So those first 2 stages of my reasoning. And so again, we end up in a factual dispute. We now know that the 28th of October email is no longer said to be a notice, so that's fallen away. And we have the 5th of November notice, which nowhere on it identifies the person on whose behalf it is being made. And the only factual case made to the board today is that a fiction should be erected, that the registrar, upon receiving the 5th of November email, should have communicated with the commissioners, asked for a full record of all of our documents, including our emails. That would have been given to the registrar, and upon scrutinising those documents from us, she would have become aware of the identity of those who'd given the notice. And I say really that's a hopeless submission, I'm afraid. It is my submission. So I say there's no factual case actually put forward to explain why that should be a notice. And in the light of my learned friend's concessions on point 1 and 2 of my reasoning, that's dispositive of issue 2 in my favour, I say. Issue 3 is the timing of the subsequent making of the application for leave. That falls away now because we don't have the registrar's letter. Time never began to run. So I don't need to go through the various cases relied on by my learned friend. I don't need to explain quite what it means when we discern the intention of Parliament in a Shahid, Synergy sense, how it's still acceptable to consider statutory purpose even with clear language, all of those points. I don't need to take you to the Article 6 cases. I don't need to engage with the engagement of Article 6. I say Article 9, of course, is on point. Section 39 sub 1 of our measure says that even when an incumbent is dispossessed and they don't give consent, still a scheme comes into force. And of course, we know that an incumbent does not have an appellate right. Only those who make written representations under the scheme have an appellate right, not an incumbent. So I don't need to go through those submissions. Issue 3 has fallen away, and in the light of indications today, I'm not pressing issue 4. So those are my reply points, and I would invite you, if I may respectfully, to find in my favour on issues 1 and 2. Unless I can be of any further assistance, those are my submissions.
Thank you very much.
I'm grateful.
Now, do you need a moment to decide how to divide up the time, the rest of the time available to you today and tomorrow, or is it something that you've already discussed?
I've already done that.
You've done that. Thank you.
Yes. We have done that, but between us, we wanted to ask whether the court might be willing to sit until 4 o'clock tomorrow rather than 3:30, which I think is when otherwise the board would rise, to give us that extra 30 minutes.
I don't think that will cause a problem.
Many thanks.
I wasn't where we want.
No, 4 o'clock's the usual time. I thought we could.
You've been released early, but no longer.
So can you tell us how the time is?
Yeah, can I do that?
Actually, the official timetable seemed to be ending at 3:10. But do you want to go to 4 o'clock?
Sorry.
Yes,
So I will speak now until 4.
yes.
Tomorrow morning, I will speak for an hour. Then my learned friend will take over. Can't remember what her timing she said she would speak, but
That's right, and I'll go till 3:30, then half an hour in reply.
Yeah. That was right.
all right.
Thank you very much.
I'm going to go straight into this one. The first question, so, yeah, my lord, can I say this? Normally I would have done a short little introduction, but because we dealt with jurisdiction, I didn't do that. Let me just do that now, just a couple of minutes about the importance of this case. Your Lord, the stakes of this case extend far beyond compliance of legal argument, and I think it's important to appreciate that. And I say that you'll see behind you the parishioners and the, just how important a case this is for the All Saints community. So I think it's important just to point that out. At the heart lies the fate of a vibrant community nurtured by the unwavering dedication of Reverend Clark and the parish church council. The outcome of this appeal holds profound significance for Reverend Clark herself, whose pioneering efforts as a black woman priest have not only transformed All Saints into a beacon of inclusivity, but have also established a sanctuary for the BMAE community in the Shirley Spring Park area. The loss of her position as an incumbent and the loss of the cure of souls within her parish will not only be devastating for her, but will be a deeply felt loss for the community in which she serves. For the PCC, entrusted with the safeguarding the spiritual and communal welfare of parishioners, the impending decision carries weighty implications for their ability to continue their vital mission. As custodians of faith and stewards of social justice, Reverend Clark and the PCC stand united in their quest for equitable treatment and the preservation of All Saints, an irreplaceable role in fostering unity and spiritual nourishment within the community. Thus, the merits of this case deeply resonate with their shared commitment to uphold the principles of inclusivity, fairness and religious freedoms that lie at the core of their calling. Let me now turn to my submissions. So the first question for your lordships in ground one, which logically precedes all the other questions, is whether the commissioners and or DMPC were acting as public authorities when they made the relevant decisions. Now, I acknowledge that, as the House of Lords made clear in Aston Canclo, that's page 1723, the fact that the Church of England Church of England is a state church does not in itself mean that all of its functions are public functions. But the church is made up of a number of different bodies with distinct roles and governed by a number of discrete statutory and ecclesiastical regulation and laws. It is one thing to say that an incumbent, a bishop or a PCC are not public authorities, but this, as we're well aware, is the first case to come before the courts which squarely considers whether church commissioners for England are a core public authority, or in the alternative, a hybrid public authority in the present context. So my primary submission is this. On this issue, we say that the commissioners are a core public authority. I fully accept that incumbents, bishops and PCCs are not core public authorities, as my learned friends rightly highlight. If they were, they would be incapable of enjoying Article 9 rights. But it's my submission the commissioners are fundamentally different from other Church of England entities. That's for two reasons. First, their primary function is the administration of property and financial matters. They themselves are not engaged in religious ministry. Second,
But sorry, aren't they charged with making provision for religious ministry? They're not purely concerned with distribution of property rights.
but charged with making provision for religious ministry is not the same as ministry, it's still an administrative function in my submission.
Right, but
Yes, but it's directed to the cure of souls.
Yes, but from an administrative point of view. Their primary function, my
You
lord.
can't take that too far without undermining the later statement, your argument.
Well, let's see how I develop this. I say the primary function is the administration of property and financial matters. The second is they are a body. Yes. Whose membership is composed partly of state officials who are directly accountable to Parliament, and I would refer in this context to the role of the Second Church Estates Commissioner, who by convention is a member of Parliament and the governing political party. The Second Church Commissioner answers oral and written questions from MPs about Church of England matters. There is therefore...
But, I mean, when you say accountable to Parliament, you mean surely they're accountable to, so far as we're concerned here, to due implementation of their function under the measure. So, I mean, they wouldn't be allowed to say, well, I'm not going to comply with my duties under the measure because it might make it awkward for me in Parliament, could they?
No, and I don't put it as high as that. But the point I make is the membership of the Church Commissioners includes appointing, their members are appointed by the Crown, as well as public office holders, as well as certain public office holders. That's as high as I put it. Look, my lords, my learned friends have placed a lot of weight on the Holy Monasteries case, and you'll find that at 3603. But we say the closest analogy to the Church Commissioners in that case was not the Holy Monasteries themselves, it was the Office for the Management of Church Property, or I'm going to use the shorthand, the ODEP, whose structure and functions were that as described, and you'll see the description in paragraphs 10 and 11, you'll find that in the judgment at page 3610, that's 3610.
It's like Albions.
And there you'll see that was an entity which was responsible for the administering of ecclesiastical property and whose governing board included state officials.
Yeah. Paragraph 10 says it's a public law entity under the supervision of the Ministry of Education and Religious Affairs. But, I mean, that's not really analogous, is it, to the Church Commission?
Well, that's right, my lord. But what we say is, it was not suggested in Holy Monastery in that case that the ODP was not an emanation of the state. Indeed, the monastery's complaint, which was rejected on the facts, was about the administration of their property by the ODEP, and the Commission specifically described the ODEP as a state institution. So,
But all this is in the context of an agreement between the Greek Orthodox Church and the state that 4/5 of their agricultural land would be transferred to the state, and they would receive in return a third of the real value of the property. I mean, and also it says, I think at the end of the first subparagraph in 10, that responsibility for the property to be retained by the church was taken away from ODEP. So it's a rather different institution. They're managing property that has been transferred to the state from the church, aren't they? Not?
yeah, my lord, if that is unhelpful, I will move on.
Yeah, I'm not saying, I'm just asking a question. I'm looking at this case as we speak, and I just wondered if it was a rather different organisation, because it does say that revenue of ODEP had to be applied for church purposes.
They ask.
Well,
They weren't a public authority, were they? Being able monasteries. So, I mean, to that extent, it's a sort of a fortiori case that you have to deal with.
well, look, my lords, it's my submission that the commissioners are in a similar position as ODEP, a state entity that administers ecclesiastical property. They are the link, we say, between the Church of England and the state. While most Church of England institutions are not called public authorities, I would submit that the commissioners are. Now, if my learned friends rely on, if this is, forgive the pronunciation, Houghton-Nenny, which you'll find at page 3600, that's three.
But am I right? I haven't read the monastery case, but what's in the written cases, but is it correct that they were not a public authority, called public authority for the holy monasteries, despite the fact then all the points you've drawn our attention to in paragraph 10?
Well, my lord,
I thought the Scottish monasteries, I could be wrong, was a complaint by the monasteries. So therefore, something separate from the state, because if they were the state, they could have
complained to state, and therefore,
but they were complaining about ODEP, which was an agency of the state, essentially for the reason that my Lord Hodge identified, that the background to this was that, in effect, the state was taking away property from the monasteries, and they were complaining about the state doing that.
Yeah.
I see.
And what I'm saying is, ODEP, who was administering the property, are in a similar position to the commissioners in this case. That's my argument.
I see. Sorry, I'm following this.
So ODEP as the respondent was in a similar position. What you're saying.
Exactly.
I see, yes.
Thank you. Apologies, it's my misunderstanding of your question.
No, you hadn't, well, it wasn't quite clear the context.
But if I may, one is taken back to paragraph 10, which makes it clear that ODEP is, in effect, under the auspices of the Ministry of Education, which very clearly is part of the state.
So,
But I mean, was there anything else you wanted to say about the commissioners?
no,
The commissioners aren't under the supervision of anyone, are they?
no, but I was drawing an analogy with the administration of property in a similar way that ODEP did. That was the analogy that I was drawing.
Yes, I see. Thank you.
Thank you. My learned friends also rely on Houghton-Nenny, that's at page 3600, against Sweden, Schuch and Germany, which is 3735. If I can just look at those cases very quickly. In my submission, those decisions go no further than to show that the status of a church body as a public law corporation does not by itself make it a public authority, and we accept that. That's right, of course. It's clear in any event from Aston Cantio. But the commissioners are in a different position, and I say that they're much more analogous to the ODEP and Holy Monastery case than to a parish or a diocese. The commissioners have rightly said that if a church body is a core public authority, it would not be able to assert any convention rights of its own. And that is true, of course. And for that reason, I would not suggest that most church bodies are core public authorities. But I draw a distinction with the commissioners, and I say that they're in a quite different position. And we've already touched upon this. Their primary function is not to engage in worship. Their primary function, I say, is the administration of property and finances, which centuries past would have been vested in them by the state.
I fear I'm going to repeat the point that I was putting to you before, but they're responsible for making arrangements for the cure of souls. I mean, if the state, if they really didn't have protection from the state under Article 9, for example, that would suggest that the state could intervene to mandate them to require particular provisions for the cure of souls, which would seem to be an extraordinary power in the state to intervene in the delivery of spiritual and religious services, wouldn't it?
That gets better.
Let me pivot then and turn to, if I'm wrong on that, if the commissioners are not a core public authority, it's my submission that they are a hybrid public authority.
I may have missed it. Do we have somewhere a statement of the precise role given by the church to the commissioners? Do we have that in the papers?
So, was it section 3? Oh no, sorry, that's the NPCs.
They exist outside the 2011 measure, actually.
I mean, there must be a measure, or maybe even primary legislation which established in the measure as a body curriculum.
Yes, but as if we look at in my written case, page 1043,
So I remember that there is a reference in
the paragraph 52,
yes, it's the 1947 measure.
it is the 1947 measure exactly which established us, for which united Queen Anne's Bounty and the Ecclesiastical Commissioners. Then we have the Harry's and the Church Commissioners case, which set out functions and objects, and I can take you to that. And then the reference to Halsbury's laws, which we have in the one at page 3788.
I'm so sorry, I missed the paragraph.
52.
52, I'm so sorry.
And in Halsbury's, we have the core functions of the Church Commissioners set out, 3788, holding and administering of the four endowments, dignitaries, application of the general fund, determination about of income, and so on. They're working down dealings with the glebe, parsonage, housing, receipt of purchase money, and so on. Then under 8, preparation of schemes and orders in relation to pastoral reorganisation, churches host for regular public worship, and other schemes has the Commissioners best adopted for carrying into full effect the provision of various enactments giving jurisdiction to the Commissioners. And of course, one of those is the measure, the 2011 measure we're considering today, with the core provision in section 1, which I took you to this morning, of making provision for the mission of the Church, that statutory definition, pastoral, evangelistic, social and ecumenical.
So where are we reading from?
Halsbury's laws is 3788,
Yes.
and then we see in 8 and 9, but 8 in particular, schemes and orders. So that's the pastoral, or the parishes, benefices and so on, organisation which your lordships are considering in this appeal. And that is fundamentally, as you've said, my Lord Hodge, provision for the better cure of souls. It's the better deliverance and furtherance of the mission of the Church. That's the section 1 obligation in the measure. But we do see the other primary functions set out there.
Yes, thank you very much.
Thank you.
I'm sorry to interrupt. It's useful just to have that in front of us.
I'm grateful.
Particularly when you're moving on to this hybrid point.
Yeah. So, if I'm wrong on my first submission, then my second submission is that they are a hybrid authority. And I'd invite your lordships to consider the checklist as set out in TH against the chapter of Worcester Cathedral, and you'll find that at, it's paragraph 64, and you'll find that at 3203 to 3204.
Sure.
And when you look at that checklist, is the body performing the task which core public authority is under duty to perform, and which it is has been delegated to it? B, to what extent is the function of governmental nature and part of public administration, and so on. You can read them for yourselves.
So sorry, 64 here, so got it.
Just sit and all. Yeah. In my submission, liads C and E are highly salient. The commissioners in this case are exercising statutory function under the measures. Measures are legislative instruments which were approved by Parliament in royal assent. They are part and parcel of the law of England. And as commissioners have acknowledged under Section 4 of the Church of England Assembly Powers Act, and that's 1919, you'll find that at page 1194, that's page 1194. Measures have the same force and effect of an act of Parliament. And as I've highlighted, the commissioners are accountable to Parliament through the Second Church England Estates Commissioner, although I take my Lord's point on that. Furthermore, I acknowledge in relation to Lim B that reorganising parishes is not inherently a governmental function, but that has to be seen in the light of the commissioners and the close links that they have with the state. And I said that they're in a similar position to ODEP in the Holy Monasteries case. Unlike parish priests, bishops and the PCC, they are much more governmental than a religious body in my submission. My Lords, I want to turn, if I can briefly, to the St Giles Exhall case, and you'll find that at page 29.
Just before we leave
Yes.
3203 and 3204, so I was just looking on paragraph 67, the conclusion applying each of those factors was that in fact none of them applied. And is this to the bishop that we're looking at then?
Yes.
And that's even though the bishop's functions are governed by a measure. But still, the conclusion is, well, that's not a statutory power in the sense of state legislation. It may have the force of an act of parliament, but it's, if you like, domestic legislation of the church, as I understand the reasoning.
Yes, my Lord, I don't dissent from that, but what it's, I take you back to the top of paragraph 64. These are indicators which the court can look at when deciding whether or not it's similar to a hybrid public function authority.
Right. I mean, A might be thought to be perhaps the critical one in any particular case.
Yes.
So if it's a hybrid authority, then what you're looking at is the function that it's actually performing to ask whether in this respect it's a public authority. So the initial focus, I would have thought, is on what is that function that's being performed, and is it of the nature of a governmental or public function?
Yeah, absolutely. And as I say, the primary function here is the administration of properties and so forth. I don't want to repeat myself. Similar to what took place in the Holy Monasteries case, analogous to ODEP.
But here we're focusing on making a pastoral scheme.
Yeah.
Rather than on the holding of property.
Well, yes, that's correct. But
If I may say so, anyway, holding property is not in itself a governmental function.
no,
Individuals hold property.
that I accept. However, what we have here is the property that's individuals, private individuals hold property aren't necessarily have provisions similar to Acts of Parliament, which govern how they should manage or mandate that property. They don't have that connection with the state, and there isn't that link with accountability to Parliament.
But neither a connection with the state nor accountability to Parliament feature in the list on which you rely at paragraph 64. I mean, as my Lord Richard says, the starting point is the body performing a task which are called public authorities under the duties of authority and which has been delegated to it. Now, the answer to that question is clearly no.
My Lords, I accept that the functions of themselves are not inherently governmental, So, for instance, the erection of memorials in a churchyard is not an inherently governmental function. However, I submit that the DMPC, in this case, was acting like a public authority. It was exercising functions conferred to it by legislation, namely the 2011 measure, which is legislation approved by Parliament and has the same force and effect as a statute. They were engaged, that's the DMPC, were engaged in making proposals to the Commissioner, who I've suggested are democratically accountable. In any case, the point may be of little importance because commissioners, if you find commissioners are public authority, that might be enough for you. My lords,
I mean, that is what I had noticed, that you relied in particular on C and E in the list. But if one looks down at paragraph 67, in the case of a bishop, neither C nor E was found to apply, and I'm just struggling a little bit to see why it applies either to the DMPC or the commissioners. So
Well, it may relate to what the particular function was in that case.
Yes.
I'm quite sure, because they used to do with safeguarding children, and maybe that they didn't have any statutory power to come under the measure in relation to that.
Mr. Thomas, yes, I mean, I understand the way you put this to be, first of all, that in making a pastoral scheme under the measure, they are using special statutory powers. Besides, the measure has, it is part of the law. And secondly, that as regards that the second church commissioner can presumably be asked in Parliament questions about how the commissioners have exercised their power. I mean, I'm making a bit of an assumption there, but I assume that he could be asked questions about that. And that's really how I understood you to be saying that C and E came into play on the facts of this case.
exactly.
But I think there is the prior question, which is wrapped up in subparagraphs A and B, which requires a focus on the particular function with which we are concerned here, which is reorganising parishes.
Yeah, and what I say, the distinction between this case and the other church cases which are touched upon in my learned friend's arguments is those other cases didn't have that statutory injection.
Yeah. Because if the function of making a pastoral scheme is not of a government nature and or part of public administration, then the fact that it's made pursuant to statutory powers may not be that important
I
a
say,
feature.
yeah, I say cannot be ignored, and that is what distinguishes this case in the Church of England from some of the other cases in terms of the powers both of the DMPC and of the commissioners.
I mean, if the Roman Catholic Church were to reorganise some of its parishes in England, the nature and effect of the reorganisation might be similar, if not identical, to that in this case. The difference would be, I think, that the Roman Catholic Church would not be exercising any statutory powers to achieve it, and you would say that that's really a critical distinction.
Exactly.
Yes, I mean, you're relying on the historic fact of the establishment of the church and the king being its supreme governor.
And I say those are really, really important.
Which explains the parliamentary involvement, as it were, but we're having to look at the matter in the context of the Human Rights Act and the perception under the Convention of what a governmental activity is, for which the idiosyncrasies of the English establishment may not be a paradigm.
Well, my lord, there it is. I set out what I say the important distinctions are.
Yeah, so it's really C and D that you rely on.
It is.
64.
It is. Can I move on then, and can I turn to the, if I'm right, and you accept my argument in relation to the hybrid core function, I think it's important to, I want to turn to the question of the issue of victim status. And at the heart of my argument lies the recognition that the scheme in question has far-reaching implications, particularly for the BAME community in the All Saints parish and the wider Shirley Spring Park area. Now, I contend that victim status extends beyond individual grievances to encompass the collective harm, inflicted upon a community marginalised by the scheme, and by elucidating the interconnectedness between Reverend Clark's ministry, the All Saints PCC, and the broader BAME community, I will seek to establish a robust foundation for my assertion of victim status. Let me seek to demonstrate the adverse effects on the scheme. Can I start with Reverend Clark? It's important to note that in reality, Reverend Clark cannot be separated from her parish. The sum of the parts are equal to the whole. In my submission, the commissioners have taken too narrow a view. The substantive breach of convention right pleaded in this case is indirect discrimination against BAME people in the All Saints community and the wider Shirley Spring Park community through the loss of a distinctive mission. Reverend Clark is, of course, a black woman.
Can I just take you up and, sorry, Thomas, I wanted to raise this at some point. You talked about the BAME community, but I mean, is there such a community? I understand there are obviously different minority ethnic communities, but to lump them all together into one community, I thought was a rather outdated, possibly way of thinking.
Yeah. I am using, I'm going to come to some statistics, and I accept, Lord Legate, what you say about the use of the term BAME being, a way of lumping it, and at times I even wince at that expression. But when I say BAME community, I'm talking about predominantly the black, Caribbean, and indeed, there's a high proportion of Asian people within the Spring Park who use and are part of this church. It's an inner London, I'm sure your lordships know the area, it's just behind Croydon. Inner London area has a great deal of poverty in the area, and there are a large ethnic minority population in the area.
Yes, and you're really using it to mean that it's a community with a significant minority ethnic.
Exactly. Exactly.
And we'll take it to mean that.
Yeah.
So don't worry about using the term if we will understand it.
I still have a concern about treating everybody as...
No, I take your concern, and my lord, I will come to some stats which I hope will, yeah. I'm a little bit stuck with the word BAME because it wasn't.
What's your choice of word?
It wasn't my choice of words.
No, but if we wish, as
It wasn't the word, though, it was the concept I was really engaged with.
but we will assume that you were talking about minority ethnic community.
Exactly.
Yes.
Now, it's important to note that what we say the commissioners in this case say that the Reverend Clark doesn't fall within this class because she's the person who ministers to the worshippers and the local residents, and it's them who are going to be deprived. We say that's not correct. First, our allegation has never just been about the loss of Reverend Clark's own personal ministry, although it's an important part of it. It's also about the loss of All Saints as a parish and the positive impact that PCC had on the diverse ethnic community in that area. I accept that the petition of appeal at paragraph 19, and you'll find that at page 876, talks about depriving the community of a valuable BAME-led ministry, but in context, this was not using the term ministry to refer solely to the ministry of Reverend Clark as the ordained minister. The term wasn't being used in a technical ecclesiastical sense. Much of the evidence set out in paragraphs 16 and 17 of the petition of appeal, pages 873 to 875, refer to the importance of a diverse PCC and diverse congregation, not just to Reverend Clark's own personal qualities. Secondly, it's important to recognise that religious ministry isn't just about providing service to others. It's a deeply personal and integral part of the minister's life. It's a two-way street. Reverend Clark's call to serve her community isn't just a job. It's her identity, it's her purpose. It does not just benefit those who are ministered to, but also to the minister. It's not just that members of the local community benefit from Reverend Clark's ministry. She also benefits from expressing her faith by ministering to them.
It's the old expression, vocation.
Exactly. And just touching upon that, in her heartfelt representations that she made before the commissioners, and you'll find these at page 420, she shared with them, quote, "I have been called and dedicated my life. Being a priest is who I am. It's part of me. I know what sacrificial ministry is, and I practiced that over the years," end of quote. And we say her dedication shines through in her supplemental representations. You'll find them at page 558, where she expresses, "I love being a priest." So, my lords, Reverend Clark isn't just a figure within the BAME, forgive me, you understand, the community she serves, she's a vital part of it. Deeply connected to its fabric, its struggles through the good times and the bad. And her son, James, paints a poignant picture, and you'll see that at pages 427 to 428, recounting their family's encounters with racism and highlighting Reverend Clark's prominent role as one of the community's leading figures. In the diverse landscape of Shirley, she stands as a beacon of hope and unity, bridging divides and fostering inclusivity. Quote, "To walk around Shirley is completely different. It's a mixed, integrated community, my mother being one of the leading figures." That's page 428. So, turning to the PCC victim status, and I accept that this very much depends on the original arguments and jurisdiction, but putting those to one side, it's my submission that the PCC clearly has victim status. The commissioners have rightly conceded that a religious association can exercise Article 9 rights on behalf of its members, and in my submission, in this context, that doesn't just mean the actual members of the PCC. It means those on the electoral roll, the parishioners, whom the PCC represents and is accountable to.
Those on the electoral roll, they can speak for them, if you're saying.
And indeed, Some PCC members have provided witness statements. Winston Thomas identifies herself. You'll find her statement at page 70. She specifically describes herself as being black. Calvert Williams at page 68. Robert Dubey at page 70 also describes themselves as members of the PCC.
So the third name was?
Robert Dubey, D-U-B-E.
Yes, in page
72.
72, thank you.
In their witness statements, they speak eloquently about the impact of the loss of the ministry on the local community. James Clark, as you know, is the PCC secretary, and he's also provided detailed representations, and you'll find those at page 427 to 433. In the out-of-time representations, he spoke powerfully about his role. Quote, "We started the PCC and the parishioners through hard work. Volunteering and labour have benefited the local neighbour and active mission. As a community that is growing together with God, All Saints strives to be a community of Christ, faithful and enduring disciples, a community of love which is hospitable and nurturing, a community of difference being vain, inclusive and transforming." You'll find that at page 550, so 550. My own friends say that the PCC doesn't have standing to pursue a complaint under Article 9 on behalf of the UKME residents and worshippers generally. The group said to have been discriminated against, but respectfully I say that doesn't make sense for two reasons. Firstly, as I've submitted, the PCC represents not just the elected members of the PCC, but all those on the electoral roll. And secondly, even if that is wrong, the PCC's own members are black and Asian.
I mean, I think it's quite important to identify who is and who isn't a victim for the purposes of the operation of the Human Rights Act. I think the problem may have been in putting it that the PCC could act for all parishioners. That's to say, people who either do or might go to the church. But as I understand it, you've narrowed, what I say you've narrowed it, what the submission you're making is that in addition to the members of the PCC themselves, they can also speak on behalf of and advance a claim on behalf of those who are on the electoral register for the PCC.
Yes.
Yes, that's the extent of it. If you like. Yes.
I say it cannot be contended that to have victim status to bring a complaint of indirect discrimination, an applicant must represent all or most of the members of the group discriminated against. I say it's sufficient to belong to that group.
Yeah.
The next question I'd like to turn to is the ambit of Article 14. Now, the Commissioners concede in the statement of facts and issues that the scheme was intended within the ambit of Article 9 for the purposes of Article 14, and in my submission that concession was rightly made, and their subsequent attempt to resolve from it now is misconceived. The appellants do not need to show that the scheme substantively breaches Article 9 rights.
No, for Article 14, if you're within the ambit of a right, you can be within the ambit of the right for a positive obligation as well as for a breach. I mean, it's well established. You don't need to show breach. And I'm not sure if the commissioners are suggesting otherwise. I think not. Yeah. You're pushing at an open door on that one.
Just so my learned friend knows, in case he wants to address this point, our ambit of Article 9 point relates to internal opposition, so that feature of the public authority ambit of Article 9 case law, which essentially says that a priest or a PCC or an internal entity of a church can't set up against the church its own Article 9 rights, because the expression of the adherence Article 9 rights is the membership of the church itself.
Yes.
And that first of all was public authority, and then in our written case we said, well, actually on reflection, maybe it's ambit, and so we raised it there as well, but I certainly didn't mean to backtrack from a broader concession, but simply to say that's a feature of the case law, and if my learned friend wants to address it,
I will,
I think the key point is you're not asserting that you need a breach in order
Absolutely
to
not.
bring into play our...
No, it's ambit, just ambit, but we know that you're outside ambit if you're a priest suing your local head priest saying, I should be able to use a different liturgy. You're not even in ambit of Article 9. Don't know if that's...
yeah, I can tell you. Lord, can I... Can I just briefly mention the Savaz case? You'll find that at page 150 in the supplemental bundle. This was a discrimination case brought by a religious denomination who were complaining that while other denominations had their religious marriages recognised, they were allowed to provide religious education in public schools and nurseries, the applicants were not. And the Strasbourg court held, and you'll find the reference to paragraph 56 at pages 168. I just invite you to read paragraphs 56 down to 58. I'm not going to read them out. 56 to 58. 56 to 58.
Sorry, could you give the page again?
Yes, of course. It's pages, it's in the supplementary bundle.
Supplemental, that's why I couldn't find it.
Yeah, 168. And it starts at page 50, but it's the quote is at page 168, paragraphs 56 to 58. And I simply made the point that the situation is similar. I assume for the sake of argument that we've got over the hurdle that we are performing a core public function, and therefore obviously the state isn't required by Article 9 to recognise religious marriages or allow religious education in public schools, but it equally isn't required by Article 9 to establish a state church. There would be no breach of Article 9 if the state de-established the Church of England and abolished the commissioners. But if the state does go beyond its obligations under the convention and say it provided additional rights, it cannot, in the application of those rights, take discriminatory measures. And what we say here is once the measures here, the additional measures here is the whether or not to dissolve a parish or not, and if it's doing that, it has to take the convention into account, particularly not act in an indirectly discriminatory way. Now, I accept, as made clear in Exen Denmark, and you'll find Exen Denmark at page 3783, that's page 3783, that a state church is not required by Article 9 to provide its clergy with the freedom to dissent from the church's belief. That this is the point that my learned friend was just raising. I accept that. So you can't have a bishop who decides to set up their own style of church within a church. That's not our submission. But what we do say, so for example, if we were complaining that Reverend Clark or parishioners had been discriminated because they didn't adhere to the theological doctrine, or they had started some theological doctrine that was incompatible with Anglican teaching, we would be on very shaky grounds. I accept that. In such a case, there would be no doubt that would be an objective and reasonable justification for the discrimination. That would be a similar situation to the Fernandez-Martinez case, and Fernandez-Martinez you'll find at page 3543, where the applicant was dismissed from his post as a Catholic religious education teacher in a state school on theological grounds, and the interference with his Article 8 rights was held to be proportionate. However, that doesn't apply here. At no time has there been a suggestion that there is any theological rationale for the scheme So there's no suggestion that Reverend Clark isn't ministering in an appropriate way. That's not the complaint made against the Reverend, nor is there anything wrong with Reverend Clark's theology or her application to mission or minister or that of her parishioners. The ground of discrimination here is one of race, and as we see when we get to ground 3, the Church of England has committed itself to an anti-racism missional imperative. And I'll take you to the lament to action. So there can be no suggestion that the theological or doctrinal autonomy of the Church of England is implicated here. That is my answer to my learned friend's point that she's just raised. My lords, I'm going to turn to the ambit of Article 8. I wonder if that might be
Would that be a convenient moment? And if you're comfortable with the extra file, you'll complete to what's I hope.
I hope so. We have to be.
Well, you'll have to just yes. Very much. The board will now adjourn and we will resume tomorrow morning.
Oh.